today's second session. Our esteemed resource person is Professor Dr. V.K. Unni, sir. Sir is currently working as a professor in the Indian Institute of Management, Calcutta. He has completed his PhD from NALSA, the University of Law, Hyderabad, in intellectual property rights. His area of interest is IPR, legal framework of corporate transactions, capital and forex market regulations, and many more. He has worked as a program director of various customized management development programs conducted for ONGC, GAIL, Oil India, Coal India Limited, Ministry of Finance, and Ministry of Statistics and Program Implementation, that is Government of India. And he has also coordinated as well as consulted on various programs dealing with intellectual property laws, banking and finance laws sponsored by Microsoft Corporations, the National Academy of Agricultural Research Management, Munich Intellectual Property Law Center, and many more. He has many awards to his name. Naming few, he has been awarded as the Thomson Edison Innovation Fellowship for the term 2016-17 by the Center for the Protection of Intellectual Property, George Mason University, Virginia, US. Also, he has been awarded by the Max Planck Indian Fellowship for the term 2008-2011 by Max Planck Society, Germany, which is the first and only awardee outside the stream of natural sciences. Apart from this, Sir has numerous books, articles, chapters published by the various reputed publication houses. He has been also invited as resource person in national as well as international conferences. Sir, I heartily welcome you. Sir will be speaking on the topic of technology and IPR. Sir, I request you to kindly begin with your session.
Yeah, am I audible? I think
Yes,
I have
sir.
unmuted myself.
Yes, sir.
So thank you so much, Professor Payal.
Yes, sir. You are audible, sir.
Thank you so much, Professor Payal, and also
sir.
Dr. Shivani for a very kind introduction. Even I enjoyed it. So in lawyer, with respect to lawyers, when the introduction is a bit, we give a very long introduction. What happens is the case becomes very weak. So I hope that's not the case here. So let us straight away start with this. That way I'm very privileged. Professor Payal has been inviting me time and again. So this session is a very generic topic, primarily concerning intellectual property and technology. So I'm not using any slides for the time being, but if you want some material on that, I will be happy to share it through Professor Payal. So all of you know intellectual property deals with human creativity. And over a period of time, intellectual property has been categorized into 7. So it's not my categorization. This is what the WTO says. The TRIPS agreement talks about 7 categories, starting with copyright. It can be trademarks. It can be patents. It can be designs. It can be geographical indications. It can be integrated circuits, or it can be trade secrets or confidential information. So amongst these 7, can anybody tell me which one has the maximum interface or interaction with the field of technology? Since this is a class where PhD scholars are there, I don't want to make it a lecture mode. I thought you will also interact equally and also educate me on this. Because whenever we talk to PhD students, the learning is always mutual, and the knowledge generated is in a way co-created knowledge. So anybody?
Patent.
Sir, I think copyright is the most used.
Copyright is the most used.
Yes,
Anybody said patents?
Yes,
If,
patent.
if video can be switched on, you can do that. I have no problem with that. So, which will also make sure that whatever little boredom can arise will also come down so that I can see the faces. Anyway, I'm going to switch on, keep the video on here, unless there is a network problem. So it's all up to you. I'll be happy to see all of you. Okay. So why do you feel patents have a very long or a very close connection with intellectual property?
Because it is
Why not
almost
trademarks?
Because it
Yeah.
is almost prevalent in every field. Patents is prevalent in every field, whether it's software, whether it's pharmaceutical, or
Okay.
whether mm, games, I mean, more or less
Hmm.
software,
Hmm.
I
Hmm.
feel.
Hmm.
So I think patterns, and because with awareness of patterns, I think a lot of I think technological thing is somewhere related to patterns.
Yeah. What about
Actually, the
trademarks? Whether
literary,
trademarks have any connection with
sir, it is copyright.
technologies? Who said
Um,
copyright?
Sir, myself,
Okay, so can you
Rajat
very
Kumar.
briefly tell me how copyright has that kind of interface?
No, it has the longest life, sir. In terms
Uh,
of
ah, yeah, go ahead. Go ahead. I am hearing you.
from the death of author, 60 years.
No, that is the duration of copyright. I am asking how is copyright connected with technology?
Sir, copyright can be violated even by technological means in a wider scale. I can give a common example of pirated CDs
Ah,
and even computer programs. Some portions are even covered by copyright.
okay. And if I understand correctly, all of you are not from the field of IP. Am I right?
Yes, sir.
Yes, sir.
How many of you are
Yes.
from the field of IPR here in this group?
No, no one, sir, I think.
No one.
Sir,
Okay,
very
okay,
few.
okay,
no,
okay.
no,
So,
my
but
topic,
still, but still,
sorry,
you are
sir,
able to,
my topic is
uh,
related to
Sir, we
clearly
are
IPR.
able to
connect the
connect.
linkage. So that's why I am surprised. It's a very good thing to happen, because if you are not from the field of IP, generally people are completely clueless. But that's not the case with this group. So I also congratulate Professor Payal for selecting such an erudite group also. So anyway, coming back to what we are discussing, intellectual property, as I told you, it deals with human creativity. And when we talk about human creativity, this can manifest in multiple ways. For example, copyright. Copyright could be anything. It could be a literary work, it could be a dramatic work, it could be a musical work, it could be an artistic work. So tell me, in each and every aspect, you will all agree with me, in each and every aspect, technology also plays a big role, right? What
Yes, sir.
about a digital file? So a literary work, which earlier was only in the form of a book, today we all know about it through a digital copy, right? Take the case of a music file. Earlier days, of course, we were hearing songs, tunes, all those things, but technology has greatly helped it to disseminate. And with the kind of websites like YouTube and various other kinds of music sites and all, any file which is kept anywhere in the world, if it is accessible freely means you can access it without any restrictions, anywhere in the world at any point of time you can download that. It means the choice, time and place is getting really simple through technologies. So starting from copyright, technologies play a major role. So it can be a digital file, it can be a digital kind of photograph, a digital recording which is happening right now. And the other interesting thing which has in a way revolutionized the interface of technology with intellectual property in general and copyright in particular is the internet. I think all of you will agree with me. So internet, when it came up or when it became more and more common, or when people started to use it, what happened was a very interesting dilemma got developed, what we generally call as digital dilemma. Have you heard about this term? Digital dilemma and copyright, or IP. So what is this digital dilemma? This digital dilemma in a way talks about trying to bring some of the traditional concepts of copyright and trying to customize that with the digital environment. So taking a step back, let us think about how copying used to happen before the age of digital, I would say. For example, before internet became popular or copying technologies became popular. Earlier also books were there. Earlier also people used to make copies. But there is a fundamental difference in the way copies were made before mid 90s or before the advent of internet to the days where copies are actually being created in the digital world. Earlier days also you had books. You used to take it to a photocopying or a shop which will specialize in making all these copies. He will ask you to come the next day or that day evening so that he can photocopy the entire thing or how many chapters you want. Then what happens is clearly you can discern, you can find out the copy from the original, because in those analogous technology days, the copy can never match the qualities of the original. So you can always say this is the original, this is the copy. Plus, that was also substantially challenged by concepts surrounding distance and time. Distance means if a book is not available in your city, unless you go to the other place or unless somebody sends you that particular book, it's almost impossible to take a copy. Time, how you get challenged. Time also, it takes some time to reach the other place, right? Even if you go by a chartered flight also, it will take some time. So imagine if a book is not available in India, it's only available in New York Law School. Either somebody should send you that, a physical copy, or you should go there, which will cost you substantial resources as far as time is concerned, distance is concerned, as well as your money is also concerned. Because if you have to travel there, or even if somebody has to send you a copy, there will be courier charges for that, which can be very expensive also. Now, come back. After taking a step back, what was happening earlier, now let us see what is happening now with the concept of digital coming into play. Take any particular material available in the internet. It can be a material which is available through a library based in New York. If you are having access to that, and you know many, during COVID times, most of these libraries made available to the general public a lot of information, even though they were actually protected by copyright. So that was a very golden period actually. So if you are able to access that, and now accessing that doesn't require any substantial investment. If you have an internet connection and if you have a device which can download some information, you can access that. And most of them, they allowed you to download also. So two very important things which were actually preventing us from getting access to real knowledge has been made possible today through the digital technologies. And here comes the role of copyright law also. So what was the dilemma here? The dilemma is the traditional field of copyright. There is one single copy. You make copies of that through some photocopying, some company or some firm which makes photocopies. Clearly, you can discern the original from the copies being made. Now come back. Today, even though you can technically take copies, when you actually make a copy in the digital world, it's very difficult to find out or discern between or differentiate between the original and the copy there. Right? Secondly, the other example where I gave my book to that particular person, the shopkeeper which takes photocopies. If I have to make one copy, he will tell me to come in the evening. If I have to take 10 copies, he will say, ask me to come after 3-4 days, which means it's taking a lot of time also. Here, copy, I can make any number of copies. I can make in split seconds, right? If not seconds actually, okay? So that's possible. No difference between original and the copy. The third is the aspect of transmission. Earlier days, I have a book. If I want to send it, couriers don't come cheap. It's very costly. Secondly, to some places, couriers may not deliver, which means those people can't get access to that. Today, through this internet, the speed with which you can transfer even some very bulky files is enormous. So this was creating a problem in the case of copyright. Why? Because copyright, generally when I teach this in class, my students in IIM, they normally come wearing to the class by wearing a t-shirt which says copyright is the right to copy, and they smile at me. In fact, copyright is not the right to copy. If I have the copyright, I can stop others from making copies of the work. I can stop others from distributing copies of the work. I can stop others from playing, showing, or performing the work in public. In your room, if you perform, no problem. I can stop people from broadcasting the work by wire or wireless means, internet. I can stop people from making an adaptation of the work. There are other rights also, but these are the most important preliminary rights or the primary rights. So technology is challenging each and every frontier here. Take the case of copies. Unlike earlier days, when you talk only about physical copies, the concept of one physical copy and n number of inferior mechanical copies is not at all relevant in the case of digital copyright. Because the moment you make the work accessible, what is happening is anybody can make n number of copies where original can't be differentiated from the copy there. So a major challenge comes with respect to the right with respect to reproduction here. Second is, in the traditional world, if I am a copyright owner, the law says that only I have the right to distribute. So if I have 50 copies of the book, as a copyright owner, I have the right to distribute those 50 copies. But if I sell those 50 copies, imagine I am selling 10 copies to Professor Pyle here. Over those 10 copies of that books, Professor Pyle can do whatever she wants. She can tear that book in front of me and laugh. She can throw it to the river there in Nagpur. I hope there is some river there. Okay. She can gift that book to her worst enemy. No problem. Only over those copies. Why? Once I sell, there is a concept called doctrine of exhaustion of rights. First sale doctrine chips in. So this stops. That means I can't control subsequent distribution by the buyer or person who gets access to me in a legitimate manner. Okay. But think about the internet situation. Think about what happens to all these software, the CDs or the copies which you are downloading by paying money. How can they control it? So that is one reason why. So the changes in technology or the way by which technology had made this copying much easier has compelled these companies to go for certain kinds of additional protection like shrink wrap contracts or click wrap contracts or browse wrap contracts. I'm sure all of you, as part of downloading something, you have to click yes or no. So coming back to the fundamentals of contract law, you don't need a written agreement in all cases. It can even be by a gesture. What is that gesture? Earlier days, when softwares used to come in the form of a CD, it was actually a string wrap. So you are shrinking that CD wrapper and agreeing to the terms of the contract. Then came a new era where you don't have to buy a CD. You can actually download the software if once you make the payment and all. But then you have to agree to the terms and conditions. And there will be multiple prompts. So once you download that, then it will go to another window where you have to click yes. And many conditions are there. So you are agreeing, once you are clicking yes, you are agreeing to the contract there. So they are offering something, you are accepting that. So it becomes a valid contract. So that also now has changed because a lot of people started saying that though we have clicked yes, we never understood the meaning of that. So, which again they'll try to say that there was some misrepresentation. They want to make it a voidable contract. All of you have studied that. So now law is coming with another version and saying that unless you browse through the contract, that's why in certain links and all, unless you browse through, you may not read it, but unless you browse the entire contents, the prompt for yes or no won't even appear. And the default will be always no. So all these are in a way challenges which the technology has posed to the institution of copyright. And unfortunately, the companies or the proponents of, I would say, the close kind of copyright model, they are not fully trusting the copyright system. So they know that copyright is there. They also agree to some extent that it can be useful. But along with this copyright, what they are doing is they are compelling all of us to enter into a contract. What is that contract? In the form of a shrink wrap license, a click wrap license, or a browse wrap license. So this is a very good example of the manner in which technology has shaken and challenged the very fundamental premise of copyright law. Because in copyright, and in the case of a software, all of you know, both the source code and the object code is protected. Object code anyways, source code also has to be. And what these particular companies are doing is, these companies, by forcing you to enter into a contract, is denying you three important freedoms. Can anybody tell me at least one freedom there? The users cannot access the source code, which is critical for you if you want to do any modification. Take the case of a book. Imagine Payal madam has written a beautiful book on how to teach in a law university. I can buy that book, read that book, get that idea, and start copying that idea. Please note, copying that idea is okay. Law, copyright law only deals with what? Expression of an idea. Because law ideas are always available for you freely. That's the fundamental law. Baker versus Selden case you should go through. But an expression you can't. And again, it's very difficult to tell you where the expression idea stops and where the expression starts. So in the case of a book, if I want to know what are the ways by which Payal madam gets the accolades of students in Nagpur University, I can read her book and copy that. I can take that idea. In software, that's not possible. Why? The buyer or the user cannot decompile and get access to the source code. The idea behind the program lies in the source code. The object code is just zeros and ones. Nobody can understand that. So this is one. Second one is, through this licensing, the string wrap, click wrap, or browse wrap, they are preventing the users from distributing the program. You would have seen that. You can't distribute it to anybody. That's why so when you buy one, they will tell you, this is only to be used on a single PC at a given point of time. If you want to use it on a second computer, the agreement says that you should first uninstall it. None of us may be doing that, but now they can easily catch you because of updates and all. And a lot of updates are coming. So if it is a pirated one, they will politely tell you, yours is not a licensed one, kindly take one. Only unless it's a large entity or a company, they won't generally go and file a case. Individuals, Microsoft or any of those companies they are very kind-hearted, like the person who introduced me. So they are all very kind-hearted towards individuals. The third one is, through this particular license, you are actually being prevented from making any modifications. In a book written by Payal madam, I can make modifications. I can even, subject to some permission, I can even make drastic modifications also. If it makes a drastic modification, it becomes a new work altogether. This all because I am getting access to the entire work. In a software, you never get that. I'm talking about proprietary model. So let us see how the business community has listened to this, or how the global community with respect to the IT industry had risen to this challenge. I'm sure all of you would have heard about open source model. Open source is a very good example of how the industry has dealt this particular challenge involving copyright and technologies. Because copyright law tried to cover a lot. Not only copyright law, these kinds of companies, I am talking about the companies using this proprietary model like Microsoft and all, where the end user can't get access to source code, the user can't distribute the program, the user cannot he cannot even modify the program. So this was curbing a lot of no intellectual creativity around making of programs. So there was another interesting model which evolved, what we call as open source model, the GPL or Mozilla and all. Here there is a copyright in place. Don't think there is no copyright. This is copyrighted by that foundation. It can be the GPL, it can be the GNU Foundation, it can be the Mozilla Public License Foundation, it can be the BSD Foundation. But after taking the copyright, what they do is a very, very interesting thing. What they do is they give a very liberal license. What is that license? That license allows you to get access to the source code. Please note, in any computer program, getting access to the source code is critical. Second one is they allow you to modify the program. Whoever is part of the open source community, subject to those terms and conditions, you can modify the program and keep it private. Thirdly, it allows you to distribute the program. So 3 rights which are denied by copyright plus a very harsh license is given to you by a rival community. No, I wouldn't call them rival. Almost, no, these are also very interesting sets of entrepreneurs. So they are giving you that right. So see, this is a very interesting way by which how the technology community has taken up this challenge openly and came with a very interesting business model. So if you want certain additional things, you have to pay for it. That's how companies like Red Hat and all came up. But if you want only the basics, it's okay, fine, no problem. You can take it. So this is just one aspect of intellectual property, copyright. And all of you know, intellectual property was there for many, many, many centuries. Can anybody tell me from which year India had its Patents Act? I think you are muted. Sujay, you are muted.
1971?
Yeah, which one?
1971?
Louder.
1971, sir.
That is the Indigenous Patents Act. I am asking,
Okay.
from which year India had a patent law?
1970.
1971, he said. You want to say 1970? I am not asking the indigenous patent law. I am asking from which year India had a patent law. I hope you will agree with me that even laws passed by Britishers are also valid. That way, if you don't recognize them, IPC is not valid. No? So, we had a Patents Act from 1857. 18, not 19. 57 or 56. So that is very interesting. You can see that. The indigenous patent law, what you said is correct. 1970, we had the Patents Act, which became, which was notified from 72, I think. But that did not change many things. Only thing which we changed primarily was to make sure that when it comes to pharmaceutical patents, India will not recognize a pharmaceutical product patent. So when it comes to pharmaceutical product patents, agrochemicals and all, 1970 Patents Act prevented companies from getting a product patent for those pharmaceutical items, which anyway has been changed now from 2005. That has been, is not there. So if anybody wants, I have written a piece in the journal, IAC journal, which is slightly famous journal. So this talks about the entire journey since we got independence till the time of I was evaluating the last 10 years of India's compliance with TRIPS agreement. So if anybody wants, I can share it through Professor Pyle. Okay. But anyway, that's not the point of discussion. What I'm saying is IP has been there for many, many, many years, many, many centuries. In fact, the first copyright statute in a common law country came up sometime in 1709, Statute of Anne, UK. Romans had it even before. Patent statute, Statute of Monopolies was there from 1623, not 1923, 1623 onwards. It's a patent act. It's called Statute of Monopolies. So patent system or IP system has been there for many, many, many years. I also told you India also had a patent law from 1857. So this is not something new. But in the last 20, 25 years, the attention being paid to intellectual property has gone up manifold. Otherwise, no, you people would not be listening to me at this point of time. No, you could have easily slept. I couldn't see anybody sleeping also, no. So it clearly shows the importance of intellectual property. And also Professor Pyle is here. She will not allow you to sleep, I heard. Okay. So anyway, what I'm saying is, so IP's importance is primarily because of two things in the last 3 decades. One is technology playing a major role, which is becoming all pervasive. I told you at least just from one branch of IP, I gave you at least 7, 8 examples. Open source, getting access, digital copies, all those. The other one is a very important international agreement called the World Trade Organization's TRIPS agreement. I'm sure all of you would have heard about it. If anybody is there who don't know what is TRIPS, I can explain what is TRIPS. TRIPS means trade-related aspects of intellectual property rights. So, what is so important in this? Sir, tell me. You're saying something? Anybody who wants to say something can interrupt me, no problem. I want this to be a dialogue instead of a monologue. Somebody, I heard some noise, that's why. So, okay. If you don't have to say, if nothing is there to be said, no problem.
Sir,
Okay, so coming back. Yeah, go ahead. Somebody was making a point. Okay, so this TRIPS agreement is one very important reason why intellectual property is gaining a lot of currency or a lot of value. The other one is technology. So within TRIPS agreement, we have some 7 kinds of intellectual property: copyright, patents, trademarks, designs, integrated circuits, many other. Amongst that, copyright has substantial interface with technologies, which I have given you some examples now. The next field, which is having the maximum it won't be fair to say copyright is having more interface with technology than patents. I wouldn't say so. The next important field where technology plays a major role is patents. If you ask me why, the answer is very simple. Patents are primarily being designed to protect the best technologies of that day. So technologies keep on changing. So today we might be talking about things like SEPs. Have you heard about SEPs? SCPs? Standard essential patents, which are the backbone of all these mobile phone companies. For example, 3G, 4G, 5G. These are all tech standards. Over these tech standards, there is a patent being granted, which is actually held by a kind of a trust. Many companies would have own patents on this. There will be thousands or lakhs of patents over this. They are all licensed to a particular society or a trust, which will later on license it to manufacturing companies like Samsung, Xiaomi, or Micromax and all. So there is a tech part to it, and there is also an international treaty part to it. So what is international treaty part? International treaty part is the World Trade Organization and TRIPS agreement playing a role. So that is one. But since our focus is on how technology plays a major role, I would say that when it comes to patents and technology, the relationship is very symbiotic. For example, patents are there to protect technologies. Some of those technologies might look very trivial to you today. But when it was actually being brought to markets, or when it came to change the lives, those were actually very complex things. Since we all came to use that, since we all knew about it, we all read about it and all, now it has become very trivial. That's it. The other important relationship is technology constantly challenges the way by which patent actually functions. As somebody was telling, for example, software. Though people say software is primarily protected through copyright, that may not be 100% true, because there is a growing jurisprudence. There is a growing jurisprudence with respect to patents dealing with embedded technologies or embedded software or machine along with the software, the combination, since the last 30 years. Similarly, technology doesn't only mean digital technologies. It can be technologies of any kind. It can be technology involving chemistry, which the application part resulted in things like molecular biology, molecular chemistry, all those things, where you go ahead and come up with a new molecule itself. It can be an ordinary chemical molecule or something like a very complex biologic vaccines I'm talking about, or anything like monoclonal antibodies and all. So technology, one is patents are there to protect technology. The second one is technologies constantly give challenges to the law of patents. For example, how many of you have heard the case called Diamond versus Chakrabarti? Anybody who has heard it, let me know, so that I'll be happy that I am talking to a very enlightened group. Anushri, you have heard? Yeah, why don't you tell so that others can also know? You are muted, I think. Anyway, I think there is some disturbance there. So Diamond versus Chakrabarti is a landmark case decided by the US Supreme Court, which actually opened the floodgates dealing with patenting of gene fragments or genetically engineered inventions. Had that patent not been granted, I'm not sure whether we would be witnessing this much of revolution in the field of medicinal biotechnology, because that particular decision opened the floodgates. Not only opening the floodgates, it also resulted in companies also getting active in this field, because this was actually done at the level of a University of Illinois. A professor from an Indian scientist, Anand Chakravarti, what he did was he actually isolated, he genetically modified a bacterium, Pseudomonas bacterium, and what they did was they applied for a patent for the process of doing that, which they got, and they also applied for a patent with respect to the bacterium there. Bacterium is not the original one. They genetically modified that so that this bacteria can treat oil spillages or oil slicks. So when it went to the US Patent and Trademark Office, they allowed the patent for the process, no problem. But when it came to the end product, which was the bacterium, they said that, sorry, we can't give you because this is having life. So anything which contains life can't be patented under the US patent law. And US patent law says that anything, if an invention with respect to machine, manufacture, composition of matter, or process is there, if it is new, inventive, and as industrial application, you can get a patent. So unlike Indian law and all, which excludes things, US law only talks about these four things: manufacture, machine, process, composition of matter. So, but US patent office did not grant the patents. They said that it's having life, so it won't fall within any of these four. So they, Anand Chakravarti, appealed to the appellate court. At that time, there was a court called CCPA, Court of Customs and Patent Appeals. They allowed the patent. They said that nothing in the patent statute prevents the patent office from granting a patent to something like this. There is no mention of the word living or non-living. Patent can be granted. Against this, the commissioner of USPTO, his name is Diamond. He filed it was a kind of an appeal, because appeals from CCPA goes to the US Court of Appeals for the US, it goes to the US Supreme Court. So US Supreme Court, I think in 1980, came up with this landmark judgment that anything made by man under the sun is patentable. So what they said was, the question is not whether it's having life or not. The question is whether it is made by man or not. So they are differentiating between an invention and a discovery. So this today, you might say, what is so new? Most of the vaccines are genetically modified. None of those things would have happened if this particular decision was just the opposite. Because what this decision did was not to just grant a patent to Illinois University or Anand Chakravarti. Instead, it opened the floodgates with respect to funding from private equity players, venture capital firms and all, to small boutique R&D firms who later on got acquired by larger players. So the entrepreneurship culture, which is getting connected through a technology, got a thumbs up from the US Supreme Court by the grant of a patent. So this is one. So even though it's not a digital technology, all of you would agree that this particular decision had huge implications with respect to all the subsequent developments on various kinds of polyclonal antibodies or MABs, what we call as rituximab. All these are monoclonal antibodies. Some of them were even used during the times of COVID. This decision, I would say, has been very, very critical, because it's not just enough to do research. You also need funds. Many a times, the state, even in US, the state government may not be able to provide funds because priorities are different there also. So unless you are able to channelize some private funding, it is very difficult to take it to the stage where it can be marketed. So this patent which has been granted, and the affirmation by the US Supreme Court that if you are actually, even if it is having some life, even if it is a living organism, if it is an invention, patent law should not be a bar. Patent should be granted. So what is this patent giving? This patent in a way helps. Patent is a monopoly, right? Patent is a qualified monopoly, I would say. So if I have a patent, I may not be able to manufacture that, but I'll be able to stop somebody from manufacturing who has complied with all the other regulations. So it's a negative right. So if I am having a patent, and if I am able to license it to a company which can manufacture, one is I'll be getting money for that. Secondly, this company can take you to the market where the profits can be mind-boggling. And this is what all these companies are doing. So if you see the COVID vaccine also, it was co-developed by Oxford, and I'm talking about the UK one. AstraZeneca and Oxford University. And many of these technologies like mRNA, which helped them to ramp up production in US very fast, was actually an offshoot of multiple R&Ds which happened in various universities in US. I think University of Chicago and all. Exact university I forgot. All are protected by patents. So this patent in a way gives confidence to the people who are investing money, to the extent that if somebody copies this or if somebody misappropriates this, I'll be getting a legally approved restraint from a court. India, of course, it takes time and all, but still, if you see the standard essential patents, how many of you have read about this standard essential patents, SEPs? In India, almost all the cases which were filed by what is that? The patent holders, most of them are Ericsson or Huawei, no, not Huawei, Ericsson and Qualcomm. In almost all the cases, they have won. And in many cases, they even got ex parte orders, which is not the right thing to do. So even in India, which is supposed to be not so patent friendly, when it comes to inventions on certain technologies which the judges feel are not that life threatening, like a mobile phone, injunctions are granted immediately. Even in India, I'm saying. In fact, Ericsson or Qualcomm has a 100% success rate when it comes to preliminary injections. I'm not talking about US or some other country, in India. Because in almost all the cases, they were able to get an injection. Of course, when it comes to pharma products, judges are a bit careful because they feel that this is something which can have implications for the life and death concept is there. So, but there, they don't give injections that frequently. But there are cases in technologies other than pharma where Indian courts also have been really fast to give injunctions. I'm not saying this is a good thing to do, but this, the way in which technology is influencing or interacting with IP is going up day by day. So let me share. So one thing I will just, I can share with you one article here. Just one thing. Yeah. So this is the one I will share with you. Professor, I can share it here na, in the chat window. Yeah. So I am sharing that. You can click it. Once you click it, you will get whatever I was saying. How this not only is this. So IP and technology is not just having a role in peaceful times. Even during COVID times, you can see the kind of impact being playing out. But anyway, this was a slightly different article, but if you read it, you'll be able to understand. And here there is no copyright issue because it's my own article. You don't have to worry about that. So I will also share some other articles are also there. I normally come in Economic Times also, I write. So this is Forbes magazine. So this you can use it. So since the lecture is for 1 hour, I will stop it here. I'll be very happy to take any questions from you because this was a one-way process. I want it to be a dialogue actually. Right. So is that okay, Professor Payal?
Absolutely wonderful, sir. It is always a pleasure to hear from you.
So I send a emoji of people jumping when listening to Professor Payal's class. You can share that with the students.
Sir, all the recordings of these sessions is available on.
So what I will do is I will send you those two articles. One is that India's TRIPS journey that's in IIC one, and there is one with respect to copyright, and also one on open source, which I mentioned. How this licensing plays out and how who can use these things and all. That was published in Illinois Law Journal. I will share with you 3 articles.
Do send it to us on our email. We will compile those in our study material only. Because anyways, we are going to give them a study material printed, so we'll give them those articles.
I'll be really delighted to have my name in that. So, but any questions if they have, they can ask me. Yeah.
Sure.
I will also share one more Economic Times write-up. I will. Okay.
Yes.
Yeah. So if anybody has a question, I will be happy to take it.
Sir, can you just share your email ID, please? Can we have it, as we are
Yeah.
not technology
Yeah. I
person?
am.
So right now we don't have any queries because we
Oh my
are
God.
actually
Okay.
child in this field. So
No. Everybody is a learner here. So, especially when you interact with PhD scholars, you also learn a lot. So, and plus, I am actually available all the time. I'm all the time free. So I am in all social media also. Facebook, what's that? Not Instagram. Instagram is for very young people. So whatever is there for oldies like me, Facebook, LinkedIn. So this is my email. I can share with you. unniv@mcal.ac.in. This is my email. But I told you, but I am in other social media also. So since I am free all the time, I am available all the time there also. Right. So let me just try to share that other article also with you, because that also is of some importance. One second, I'm just searching it.
Sir, my coordinator will call you, and you can
Yeah.
just send us the link on email so that we can take the printout and compile those articles in
Oh,
the study
okay. That
material.
also would be great. Let me
So,
one
because in
second.
this
Yeah.
chat window, it might go after some time, na? So better
Oh,
we should
okay.
take it in our email, and then we can
Yeah.
share
That
it with
anyway
the
I will do.
participants.
That anyway I will do
Yeah.
that. Okay. So this is the one. I'll just sharing it. I got it actually. So only thing is, yeah, I'm sharing it here. No, one second. I can share the screen now. Can I share from here?
Yes, sir. Yes.
Can you see that now? Can you see the screen now? No.
No, sir.
No, sir.
yes, sir, we can.
Yes, we can
Yes, sir,
see,
we
sir.
can.
Yeah. I think you can see. Only certain people in Nagpur can see it, it seems.
No,
Yeah.
everybody can see it.
Yeah, this is the one. So anyway, you don't have to worry about the IP issues. Copyright is mine only, so no problem. So okay, so coming back, I will let me also, if possible, I can also share the text here. Yeah, this is the one. This came in Economic Times, and there was a discussion in Times Now also. So I was there at that time. That's why I say all the time I am free actually. So you can message me. This is my email. Yeah. So that's it from me. So I hope I have gone by exactly by whatever time madam has given me. So, but any other doubts, if anything is there, you can ask me. Else,
Yes, sir.
my very best wishes to all of you. And also congrats for joining this particular program.
Thank you, sir. Sir, I would like to give a vote of thanks to you on
Yeah.
behalf of postgraduate teaching
Thank you
department.
for thanking me.
Most welcome, sir. So on behalf of Postgraduate Teaching Department of Law, Nagpur University, I would like to extend my heartfelt gratitude towards you, sir, for sharing your immense knowledge as well as your expertise in this particular topic in technology and IPR. Sir has rightly said or explained about the digital dilemma, which is trying to communicate, or you can say customize, with how copyright is being customized with the digital era, the brief idea about what is copyright, what is patent, what is SCPs, or how the licensing of copyright is taking place, or the how technology is constantly challenging patents. So, sir, I think it is very informative and knowledgeable to all the participants present out here. And I would really once again thank you, sir, for joining us or taking our invitation for giving us this lecture.
Yeah. As I already told, it's my great pleasure to meet all the scholars. So this is one on 5G and licensing. You can also have a look. So I've shared it. So anyway, thank you so much. And
Thank
I
you
hope
so
we will be
much, sir.
meeting soon.
Thank you so much.
Thank you. Thanks a
It's
lot, Professor
always a
Payal.
pleasure.
Yeah.
Thank you so much.
Thank you so much.